very essence of civil liberties certainly consists in the right of every individual to claim the protection of the laws whenever he receives an injury. One of the first duties of government is to afford that protection. The government of the United States has been emphatically termed a government of laws and not of men. Howdy everybody, and welcome. You are watching The Defenders of Rights. We are going to be bringing you a new mini-series, and we're going to call it Learning the Law. And the first few episodes are going to consist of going over a document titled The Constitutionally Protected and Secured Right to Locomotion and Personal Liberty, the Right to Travel, and a Private Conveyance / Private Automobile. This document is approximately 1,300 pages long, and it is written and prepared by one of the members of the Defenders of Rights, Jonathan of the House Abbott. Obviously, this is for educational purposes. This is why we are bringing this to you. Now, this little mini-series that we're calling Learning the Law is going to consist of more than just what this title portrays. In this document, there are a lot of facets of the law that is discussed in grave detail, like due process of law, such as the constitutions governing the Indiana Republic. We talk about fraud, and we talk about a driver's license and an operator's license. We discuss in detail plenty of case law that is incorporated into this document. There's so much that we're going to be discussing that you're going to want to stick around to listen and find out and learn about the law. Now, before we get started, we just want to say thank you to all of those subscribers who have supported us, who have liked our content and shared our videos and tried to spread the message on the corruption occurring here in the Columbus, Indiana Republic. We couldn't be more appreciative. We thank you so much. We thank you for those who have liked our videos and have commented to us as well. We appreciate the interaction that we have with our community. But first and foremost, we want to thank the Lord for all of His blessings, for giving us the strength, the courage, and the wisdom to do what's right and to fight for what's right. Because this tyranny we're going up against is very difficult to bear. It is a huge burden to bear. But the Lord doesn't give you anything that you cannot handle, and you can bet your butt the Defenders of Rights can handle it. Now, for all of those subscribers out there and all those who view our channel, please hit the like button, subscribe to our channel, spread the message, share these videos, get as much people as you can to watch this content because we need all the support that we can get. And again, we thank you so much for all the support that we do have from our subscribers and those who have taken the time to comment to us, message us about their opinions and how they feel. Any publicity is good publicity. Now, on the first episode of Learning the Law, we're going to be reviewing and discussing in detail Chapter 2 in the document titled The Constitutionally Protected and Secured Right to Locomotion and Personal Liberty, the Right to Travel, and a Private Conveyance / Private Automobile. Chapter 2 is titled The Duties of the Licensor / BMV, Regulations and Statutory Requirements. Let's dive into it, shall we? Every state of the Union is different, and each have a government agency who has been delegated the power to handle the licensing and registering policies and procedures when dealing with motor vehicles. In other states of the Union, the agencies are called the Department of Motor Vehicles, the DMV, but here in the Indiana Republic, it is the Bureau of Motor Vehicles, BMV, and the Commissioner of the Bureau. Indiana Code, Title 9, Section 9-14-7-1, Creation of Bureau. The Bureau of Motor Vehicles is created. Indiana Code Title 9, Section 9-14-7-2, Appointment of Commissioner of Bureau. The Governor shall appoint a Commissioner to administer the Bureau. The Commissioner serves at the pleasure of the Governor. Subject to Indiana Code Section 4-12-1-3, the Governor shall fix the salary of the Commissioner at the time of appointment. So here we go. The BMV is created as well as the Commissioner who operates the Bureau. Indiana Code Section 9-14-1-8 describes the duties of the Commissioner. Indiana Code Section 9-14-8-2 and Indiana Code 9-14-8-3 describe the duties and powers of the Bureau of Motor Vehicles, which consist of the licensing and registration of motor vehicles. Here are a few articles in regards to registering a vehicle. The annual report of the Attorney General of the State of New York, issued on July 21st, 1909, at New Albany, New York, pages 322 to 323, which reads, There is no requirement that the owner of a motor vehicle shall procure a license to run the same, nor is there any requirement that any other person shall do so, unless he proposes to become a chauffeur or a person conducting an automobile as an employee for hire or wages. Yours very truly, Edward R. O'Malley, Attorney General. Interesting. This annual report has been found in many documents that you can find throughout the internet. I did find it, I did research it to verify it, and it is authentic, ladies and gentlemen. Next is a court case from the Supreme Court of the North Carolina Republic back in 1925. This is Carolina Discount Corporation versus Landis Motor Company. Since a sale of personal property is not required to be evidenced by any written instrument in order to be valid, it has been held in North Carolina that there may be a transfer of title to an automobile without complying with the registration statute, which requires a transfer and delivery of a certificate of title. Well, there's a court case revealing truth. We're going to dive into more on what the Indiana Code as well as the United States Code and the Code of Federal Regulations says about registering your vehicles. Registering your private conveyance / private automobile, should I say. Next, we have the California Vehicle Code, Division 1, words and phrases defined, Section 260. A commercial vehicle is a motor vehicle of a type required to be registered under this code, used or maintained for the transportation of persons for hire, compensation, or profit, or designed, used, or maintained primarily for the transportation of property. B. Passenger vehicles and house cars that are not used for the transportation of persons for hire, compensation, or profit are not commercial vehicles. That's interesting. C. Any van pool vehicle is not a commercial vehicle. That's self-explanatory. Next, we have a letter addressed to Judge Phyllis R. Streetle from Chester County Court of Common Pleas, located at 2 North High Street, West Chester, Pennsylvania, 19380 on April 18, 2006, written by Samuel E. Rohr, member of the 128th Legislative District of the House of Representatives, located in Harrisburg in the Commonwealth of Pennsylvania, specifically stated in this letter that he wrote to this judge. This, ladies and gentlemen, is also authentic. I researched this and found this, and I wanted to show you all what a member of the House of Representatives had to say about your right to locomotion and personal liberty, also known as the right to travel. Dear Judge Streetle, it has been recently brought to my attention that on March 26, 2006, Mr. William Taylor Rail, a defendant in criminal action number blah 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 before the Court of Common Pleas, was found guilty of violating 2 provisions of the Transportation Code. I have come to know Mr. Rail very well during the past 14 years, and I respect his understanding of the law concerning the right of an individual to travel, among other things. I believe Mr. Rail has a better understanding of this area of the law than many licensed attorneys. While I am not a licensed attorney, I have asked a member of my staff who is a Pennsylvania licensed attorney to examine Mr. Rail's understanding of this complex issue. The conclusion reached by my staff member was that Mr. Rail has thoroughly researched the issue and has based his arguments on solid legal precedent. I have also performed my own in-depth research over the years, and I too have reached the conclusion that Mr. Rail stands on solid legal footing. The crux of this issue is whether Title 75 can properly be applied to an individual. Within an individual's right to liberty is the inherent right to travel. If one's movement can be restrained, such restraint is intrinsically a restraint of his liberty. Mr. Rail's use of an automobile is simply an extension of his personal liberty to move about as he wishes. My research and that of my staff confirms that Title 75 can only properly be applied to commercial vehicles and commercial use of the roads. An individual who wishes to utilize an automobile or other means of conveyance in order to exercise his right to travel cannot lawfully be required to obtain a license to drive or to register his automobile in order to operate it freely on our roads. I have not reached the above conclusions without understanding the vast implications that would follow from these conclusions. I am well aware that a ruling of this nature would undo the years of enforcement of our existing laws. I am also aware of the enormous economic impact such a ruling would have on the Department of Transportation. However, no one today would argue that we should not have eliminated slavery because it was too costly to the American economy. When rights are being violated, no cost is too high to return those rights to the individuals who hold them. Slavery is the ultimate restriction of one's liberty. It limits one's rights in every conceivable way, including one's right to move about freely. Likewise, refusing to acknowledge an individual's right to travel is an unconstitutional restriction of one's liberty and should not be permitted to continue in Pennsylvania. That's not the end of it, but that's where we're going to cut off right there. because what Samuel Rohr just said is so true. That is what we're going to be discussing in this chapter. We have a few court cases to go over here shortly. Next, we have a definition, stricti juris, from Black's Law Dictionary, revised 4th edition, page 1591, of strict right or law, according to strict law. A license is a thing stricti juris, a privilege which a man does not possess by his own right, but it is conceded to him as an indulgence, and therefore it is to be strictly observed. So, a driver's license is a stricti juris. The DMV/BMV are agencies directly dealing with interstate commerce. These agencies are strictly for individuals engaged in business activities on the public roads and highways. The information created in surrounding the stricti juris doctrine regarding a particular license, which may or may not be represented by or revealed within the contents and control of a license agreement, must be revealed before the acceptance of a license or contract or upon demand, and failure to do so is concealment, a withholding of material facts, the inducing contractual consideration known by those who have a duty and are bound to reveal. As stated in Decatur versus Manufacturers and Traders Trust Company, which was the District Court of New York in 1938. The essence of fraud is wrongdoing. Concealment means the withholding of something which one knew and which one, in duty, was bound to reveal. That saying right there, that the BMV employees are duty-bound to give us material facts regarding the driver's license or whatever license that you may be getting. A lot of us receive an operator's license here in the Indiana Republic, fraudulently, might I add. Under fraudulent pretense, we obtain an operator's license so we can travel upon the roads and highways to get back and forth to work, to go to the grocery store, to take our kids to the park, etc. Indiana Code Title 9, which is Motor Vehicle, Section 9-32-2-15.2, Fraud. Fraud means 1. A misrepresentation of a material fact, promise, representation, or prediction not made honestly or in good faith. Or 2. The failure to disclose a material fact necessary in order to make the statements made, in light of the circumstances under which they were made, not misleading. Now, after the definition of fraud provided to us from the Indiana Code, there are some case law defining fraud. We're going to skip over that. We're also going to skip over the definition of compel and how all of us constitutional private citizens are being compelled to obtain a driver's license. We're going to jump straight to the juicy stuff. Now, this is where you want to pay attention. I'm going to go over plenty of case law, and I'm only going to read what I have underlined in those cases. We're going to start off with Reno versus Condon. This was the U.S. Supreme Court in 2000. I'm going to read to you the most important part. The United States asserts that the DPPA is a proper exercise of Congress's authority to regulate interstate commerce under the Commerce Clause, U.S. Constitution, Article 1, Section 8, Clause 3. The United States bases its Commerce Clause argument on the fact that personal identifying information that the DPPA regulates is a thing in interstate commerce, and that the sale or release of that information in interstate commerce is therefore a proper subject of congressional regulation. The U.S. Supreme Court in Reno versus Condon specifically identifies the motor vehicle information, including the driver's information, as articles of commerce. So, the Bureau of Motor Vehicles, the BMV, is an agency that specifically deals with transportation, meaning everything accomplished through the BMV is for commercial purposes. Obtaining a driver's license, registering an automobile, and acquiring insurance are all articles of commerce, which commerce, by definition, in Black's Law Dictionary, 6th edition, page 269, means this: the exchange of goods and productions or property of any kind, the buying, selling, and exchanging of articles, intercourse by way of trade and traffic between different peoples or states and the citizens or inhabitants thereof, including not only the purchase, sale, and exchange of commodities, but also the instrumentalities and agencies by which it is promoted, and the means and appliances by which it is carried on, and transportation of persons as well as of goods, both by land and sea. The term commerce means trade, traffic, commerce, transportation, or communication among the several states, or between the District of Columbia or any territory of the United States and any state or other territory, or between any foreign country and any state, territory, or the District of Columbia, or within the District of Columbia or any territory, or between points in the same state but through any other state or any territory or the District of Columbia or any foreign country. Next, we have 3 definitions of commerce, 2 deriving from Title 15, Commerce and Trade in the United States Code, and 1 deriving from Title 49, Transportation from the United States Code. We're going to skip over that. So, if any constitutional private citizen of the Indiana Republic or American citizen or state national uses the public roads and highways for profit or gain, such as truck drivers, chaperones, utility truck operators, taxi drivers, chauffeurs, etc., then one must obtain a driver's license, the privilege of using the highways as a means of one's livelihood, and have the vehicle registered, in which case the vehicle becomes a motor vehicle, the conveyance used for commercial purposes. And, as a result, the motor vehicle becomes public property. The public has an interest in the use of the vehicle. If one is using their private conveyance / private automobile to travel back and forth to work, to the grocery store, visiting family, etc., then one is not required to obtain a driver's license or required to register their private automobile through the DMV/BMV because the right of the citizen to travel upon the highway and to transport his property thereon in the ordinary course of life and business differs radically and obviously from that of one who makes the highway his place of business and uses it for private gain in the running of a stagecoach or omnibus. The former is the usual and an ordinary right of the citizen, a common right, a right common to all, while the latter is special, unusual, and extraordinary. As to the former, the extent of legislative power is that of regulation. But as to the latter, its power is broader. The right may wholly be denied, or it may be permitted to some and denied to others because of its extraordinary nature. This distinction, elementary and fundamental in character, is recognized by all of the authorities. That right there is Ex parte Dickey, the Supreme Court of the West Virginia Republic in 1915. Beautifully said. The next few pages consist of other court cases that have declared the same thing. We're going to jump over those because we have another episode dedicated strictly to just case law dealing with the right to travel. We have more important things to discuss in this episode. Next, we are going to read Robertson versus Department of Public Works. This was the Supreme Court of the Washington Republic in 1934. And remember, I am only going to read what I have underlined in these cases. Let's start. End quote. We know of no inherent right in one to the use of the highways for commercial purposes. What? Did you all hear that? Let's read this again. End quote. We know of no inherent right in one to the use of the highways for commercial purposes. Yes! We've been saying this the whole time. Let's go further. The highways are primarily for the use of the public, and in the interest of the public, the state may prohibit or regulate in any way it sees fit the use of the highways for gain. This is where the state can impede your privileges. It can't impede your rights, but it can impede your privileges, and a privilege, obviously, is to operate a motor vehicle upon the streets and highways. Let's go further in this. It is well-established law that the highways of the state are public property, that their primary and preferred use is for private purposes, and that their use for purposes of gain is special and extraordinary, which generally, at least, the legislature may prohibit or condition as it sees fit. The power of the state to limit only in that it cannot unreasonably burden interstate commerce under the guise of exercise of police power, nor discriminate against users in the same class. While the regulation of motor vehicle transportation for gain is a legislative prerogative, exercise of the function is necessarily an administrative one. It requires expert knowledge and investigation, which neither the legislature nor the courts can acquire at first hand. Cognizant of the necessities of the situation, the legislature, having enacted appropriate laws for regulation of such traffic, has delegated to the Department of Public Works the function of administering the law and regulating traffic within its purview. So this court case, Robertson versus Department of Public Works, the legislature delegated power to the Public Works to function as the administrative agency in dealing with regulating traffic. Next court case is Bacon Services Corporation versus Huss. End quote. It is obvious that those who operate motor vehicles for the transportation of persons or property for hire enjoy a different and more extensive use of the public highways. Such extraordinary use constitutes a natural distinction and a full justification for their separate classification, and for relieving from the burden of the license tax those who are merely employ the public highways for the transportation of their own property or employees. Next court case is Slusher versus Safety Coach Transit Company. This is the Court of Appeals of the Kentucky Republic in 1929. It may be assumed that the right to work for a living in the common occupations of the community is of the very essence of personal freedom and opportunity. Indeed, a citizen may have, under the federal Constitution, a right to travel and to transport his property upon the highways by motor vehicle, but he has no right to make the highways his place of business by using them as a common carrier for hire. Such use is a privilege which may be granted or withheld by the state in its discretion without violating any provision of the state or federal Constitution. The highways belong to the public, but are primarily for the use of the public in the ordinary way. Their use for the purposes of private gain is special and extraordinary, and, in general, may be restrained, prohibited, or conditioned as the legislative power may prescribe. It is essential to the proper use of the highways and to secure adequate services to the public that the business of motor transportation for hire should be regulated, and those who avail themselves of the regulations and observe them must be protected from unfair competition by those who do neither. Next court case is Jarrell versus Orlando Transit Company. This was the Supreme Court of the Florida Republic in 1936. The right to use the streets and highways of a municipality for the conduct of a strictly private business is not inherent. It can be acquired by permission or license from the city, whose power to withhold or grant it in the manner and to the extent it may see fit is an essential prerogative of the municipal government. The theory underlying these decisions and many others not included is that the streets and highways are constructed at public expense for the convenience, comfort, and use of the public. If they are permitted to be preempted and appropriated for private enterprise, then their very purpose is defeated, and those who bear the burden of their construction are deprived of the objective they set out to accomplish. There is then no such thing as a natural right to the use of the public highways for commercial purposes. Such limited right as the public may grant to use them for private businesses is merely a privilege that may be restricted or withdrawn at the discretion of the granting of power. Whether the grant is by license, permit, or franchise is immaterial. Let's read that again. Whether the grant is by license, permit, or franchise is immaterial. The power to do so is plenary and may extend to absolute prohibition. The right may be granted to one and withheld from others, or it may be withheld from all without transgressing any state or federal constitutional guarantee. So that court case was specifically talking about franchises, and we'll discuss that in a different episode. But that is key, franchises, because the civil statutory law is franchise law. Okay, so Public Services Commission of Wyoming versus Grinshaw, the Supreme Court of the Wyoming Republic in 1935 is also declaring the same thing, as well as Adam versus Burke. That is the Court of Appeals of the Kentucky Republic in 1948. It is also declaring the same thing. Okay, so the exclusive power and control of the roads within a city is conclusive and is evidenced in Indiana Code Section 9-20-1-3. Let's read. Indiana Code Title 9, Motor Vehicles, Section 9-20-1-3. Except as provided in subsection E, local authorities with respect to highways under their jurisdiction, except highways in the state highway system and state-maintained routes through cities and towns, may by ordinance do the following. 1. Prohibit the operation of trucks or other commercial vehicles. 2. Impose limitations as to the weight, size, or use of those vehicles on designated highways. So there you have it. There is the plenary power of the legislature exercising their power over commercial vehicles as shown in the Indiana Code, not by private conveyances. Next, we have Indiana Code Title 9, Motor Vehicles, Section 9-13-2-188. Truck defined. Truck means a motor vehicle designed, used, or maintained primarily for the transportation of property. Indiana Code Title 9, Motor Vehicles, Section 9-18.1-13-1. Commercial vehicle defined. As used in this chapter, commercial vehicle means a motor vehicle used in commerce to transport property. If the motor vehicle, 1, has a declared gross weight of at least 16,000 pounds, and 2, is subject to the commercial motor vehicle excise tax under Indiana Code Section 6-6-5.5. Transportation in the definition of truck in the Indiana Code is pertinent to commerce. It is one of the many words that is a term of art or a word of art, which are chosen words or terms that have a completely different meaning in law than they do in the common tongue. Let's define transportation. Title 49, Transportation, United States Code, Section 13102. The term transportation includes a motor vehicle, vessel, warehouse, wharf, pier, dock, yard, property, facility, instrumentality, or equipment of any kind related to the movement of passengers or property, or both, regardless of ownership or in an agreement concerning use, and B, services related to that movement, including arranging for receipt, delivery, elevation, transfer and transit, refrigeration, icing, ventilation, storage, handling, packing, unpacking, and interchange of passengers and property. Transportation means commerce. Words of art and their definitions play an important role in deceiving the constitutional private citizens of the Indiana Republic / American citizens / state nationals, as well as statutes and code systems with thousands and thousands of pages to review and interpret, such as the United States Code, the Code of Federal Regulations, and the Indiana Code. That is true. Words of art play a big role in deceiving the public, and that's where it all starts for those holding public office. Okay, we're going to skip the next few pages and jump straight to the juicy stuff. Driving is an activity that is commercial in nature. The definition of driver, according to Bouvier's Law Dictionary, 8th edition, volume 1, page 940, is defined as one employed in conducting a coach, carriage, wagon, or other vehicle with horses, mules, or other animals. Driver, according to Black's Law Dictionary, revised 4th edition, page 585, is defined as one employed in conducting or operating a coach, carriage, wagon, or other vehicle with horses, mules, or other animals, or a bicycle, tricycle, or motor car, though not a street railroad car. A person actually doing driving, whether employed by owner to drive or driving his own vehicle. So, by definition, a driver is someone who is employed doing business upon the streets and highways. Let's go to the Indiana Code. Indiana Code Title 9, Motor Vehicle, Section 9-13-2-47. Driver means a person who drives or is in actual physical control of a vehicle. That's pretty vague, of course. They're going to try to be deceitful and hide the true meaning of driver. Title 49, Transportation, Code of Federal Regulations, Section 383.91. Number 1, it defines commercial motor vehicle. We won't go into that until later. Number 2, driver means any person who operates any commercial motor vehicle. Let me read that again. Driver means any person who operates any commercial motor vehicle. That is the definition of driver according to the Code of Federal Regulations. Further down is 3. Vehicle means a motor vehicle unless otherwise specified. Right there they get you with vehicle. So vehicle automatically means motor vehicle unless you specify it differently. Title 49 Transportation Code of Federal Regulations, Section 382.107 defines commerce. It also defines driver. Driver means any person who operates a commercial motor vehicle. This includes, but is not limited to, full-time, regularly employed drivers, casual, intermittent, or occasional drivers, leased drivers, and independent owner-operator contractors. And again, it continues to say, a person who operates a commercial motor vehicle. Title 49, Transportation, Code of Federal Regulations, Section 390.5. Operator, see driver. Driver means any person who operates any commercial motor vehicle. So an operator is synonymous with driver. They both mean the same thing. Let's see it in Custer v. State. This is the Court of Appeals of Indiana, 3rd District in 1994. One operates a vehicle if he drives it or is in actual physical control of it upon a highway. There it is. Next court case is Whelan v. Director of Revenue. This was Missouri Court of Appeals, Western District in Bank in 2000. The term drive, driving, operates, or operating means physically driving or operating or being in actual physical control of a motor vehicle. As used in this chapter, the term drive, driving, operates, or operating means physically driving or operating a motor vehicle. And there's those terms of art we've been looking for, and that's what those mean. Next is a court case that I'm going to discuss the overall view of it. It is Terpstra v. State. This is the Court of Appeals of the Indiana Republic, 4th District in 1988. In the Terpstra v. State case, the Court of Appeals of the Indiana Republic explains many different legal facets of the law. The defendant, Terpstra, presents to the court the same concepts of the law that this document presents, but doesn't provide the court with much legal points and authorities on the subject, nor asserts his constitutional rights the proper way. One of the legal facets this case presents is the appearance of a party, as the defendant appeared pro se rather than appearing in proper persona, which is discussed in detail later within this document. Another facet is the police power of the State of the Union. The legislatures may enact laws providing for the health, safety, and welfare of the public, but the legislature cannot arbitrarily make laws that impair the constitutionally protected and secured rights of all the constitutional private citizens of the Indiana Republic, American citizens, or state nationals under the guise of the police power of the State of the Union. The Court of Appeals declares, if Terpstra desires to drive a motor vehicle on public roads in Indiana, he must comply with the applicable Indiana law. The Court of Appeals is correct when it says that Terpstra must comply with the applicable Indiana law when it comes to driving a motor vehicle, because a motor vehicle, as aforementioned, is a conveyance used for commercial purposes. When automobiles are registered, they become public property. This is why the legislature may enact statutes that provide for the public welfare and safety when legislating for motor vehicles, because motor vehicles are public property. The public has an interest in its use. Private rights and private property is beyond the powers of the legislature, only by reasonable regulations as specified by the Court of Appeals when it stated, the concepts of religious freedom embodied in the 14th Amendment have never been construed as absolute rights, beyond reasonable regulation under the state's police power. Reasonable regulations are in accordance with the law of the land, because every constitutional private citizen of the Indiana Republic, or American citizen or state national, has unalienable/inalienable rights, which cannot be relinquished at all except for where someone injures another's unalienable/inalienable rights. In addition, the Court of Appeals of the Indiana Republic also specifies that driving is an entitlement, also known as a privilege. It further validates the legal memorandum of fact and law in this document by stating, while there exists a fundamental right to travel, neither this court nor our Supreme Court nor the United States Supreme Court has ever held that there exists a fundamental right to drive a motor vehicle. To drive, or any grammatical variation thereof, like driving, driver, driven, etc., means to use the public streets and highways in an extraordinary way, for commercial purposes, for profit or gain. Another word of art that verifies a driver is someone involved in commercial activities is the term passenger. Let's define passenger. According to Black's Law Dictionary, revised 4th edition, page 1280, passenger means a person whom a common carrier has contracted to carry from one place to another, and has, in the course of the performance of that contract, received under his care either upon the means of conveyance or at the point of departure of that means of conveyance. One carried for hire or reward, as distinguished from a guest, who is one carried gratuitously, that is, without any financial return except such slight benefit as is customary as part of the ordinary courtesy of the road. Now, according to Black's Law Dictionary 6th edition, pages 1123 to 1124, passenger means, in general, a person who gives compensation to another for transportation. The word passenger has, however, various meanings depending upon the circumstances under which and the context in which the word is used. Sometimes it is construed in a restricted legal sense as referring to one who is being carried by another for hire. So, as you can tell, the legal definition of passenger is someone who gives compensation to a driver for transportation. Another word which is contradictory to the general public usage of that word. Those who travel with others in their private conveyance/private automobile are considered guests, not passengers. Next, we have Rugg versus Kovac. This is the Supreme Court of the Indiana Republic in 1984. Neither this court nor the United States Supreme Court has ever held that there exists a fundamental right to drive a motor vehicle. While the United States court has blurred the distinction between right and privilege with respect to driving, that court did not define driving as a right, but rather referred to it as an entitlement. Likewise, there exists no fundamental right to drive based upon a fundamental right to employment. We also do not think that the fundamental right to interstate travel implies a fundamental right to drive, since the voluntary induced suspension of a person's driver's license does not necessarily curtail the person's freedom to move from state to state. That right there is very interesting. We're going to dive into that further. First, we're going to read Marr versus State. This is the Court of Appeals of the Indiana Republic, 3rd District in 1993, saying the same thing as the prior case. End quote. While the United States courts has blurred the distinction between right and privilege with respect to driving, that court did not define driving as a right, but rather referred to it as an entitlement. Continuing to note 4 in this case, there is no federal or Indiana fundamental right to have a driver's license. There is no fundamental right to drive based on a fundamental right to employment. And the suspension of an individual's driver's license does not implicate or involve the right to travel or the right to migrate. Holy cow! What the Supreme Court and the Court of Appeals of the Indiana Republic means is someone who is being charged with operating a motor vehicle while their driver's license is suspended has nothing to do with one's right to locomotion and personal liberty or the right to travel because of the subject matter. A driver's license has to do with transportation via commercial use, and the right to locomotion and personal liberty, the right to travel, has to do with common right. A right and a privilege are two different subject matters. Even if one has their driver's license suspended, one's right to locomotion and personal liberty, the right to travel, cannot be impeded because the right to locomotion and personal liberty in one's private conveyance / private automobile along the streets and highways has nothing to do with driving or being a driver, which is an individual operating in a commercial motor vehicle. The private conveyance / private automobile of a constitutional private citizen of the Indiana Republic or American citizen or state national is considered a motor vehicle only when he or she is a driver or driving operating in commerce. This implies a few maxims of law. He who receives the benefit should also bear the disadvantage. Bouvier's Maxims of Law, 1856. In addition to that, he who derives a benefit from a thing, in this case property, ought to feel the disadvantages attending it. That is also Bouvier's Maxims of Law, 1856. The implication to this is, if one accepts a benefit, in this case the property, and uses it in a way it is intended to be used, then one accepts the obligations that pertain to the loan of the benefit, in this case property. So, when a constitutional private citizen of the Indiana Republic or American citizen or state national applies for a driver's license, which is government property, and receives temporary custody of the license, which then the private citizen becomes a custodian over government property, then he or she is presumed to accept the obligations of the vehicle code. However, even though that constitutional private citizen of the Indiana Republic or American citizen or state national is in possession of the driver's license, that private citizen may use the streets and highways without using their driver's license. In essence, someone who has a driver's license is only permitted to use their license when he or she is using the public streets and highways for compensation or for hire. When that private citizen is exercising their constitutionally protected and secured right to locomotion and personal liberty, the right to travel, and not using the public streets and highways for compensation or for hire, then that private citizen is not subject to regulation and are not considered by legal definition a driver. The use of government property is what creates the obligation, not the possession of the property. Simply having possession of a driver's license does not create any obligations. So, back to the legal terms and definitions. In the common tongue, a driver or an operator are someone who drives or operates a vehicle from point A to point B. By legal definition, a driver and an operator are someone employed and operates any commercial motor vehicle. Driving is not a right but an entitlement. Therefore, a driver is specifically involved in commerce, and those who are not involved in commerce are called travelers. Let's look at the definition of traveler, shall we? According to Lockett v. State, which was the Supreme Court of the Alabama Republic in 1872, as well as Burst v. State, which is the Supreme Court of the Indiana Republic in 1883, the word traveling has no very precise or technical meaning when it is used without any limitation. Its primary and general import is to pass from place to place, whether for pleasure, instruction, business, or health. That definition right there is how Black's Law Dictionary also defines traveler. Another term of art used to deceive the masses is motor vehicle. Title 18, Crimes and Criminal Procedure, United States Code, Section 31. Motor vehicle means every description of carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes on the highways in the transportation of passengers and property or cargo. Pursuant to Title 18, Crimes and Criminal Procedure, United States Code, Section 31, the term used for commercial purposes means the carriage of persons or property for any fare, fee, rate, charge, or other consideration, or directly or indirectly in connection with any business or other undertaking intended for profit. Indiana Code, Title 35, Criminal Law and Procedure, Section 35-31.5-2-207. Motor vehicle has the meaning set forth in Indiana Code, Section 9-13-2-105A. Let's go to that section, shall we? Indiana Code Title 9, Motor Vehicle, Section 9-13-2-105. Motor vehicle means, except as otherwise provided in this section, a vehicle that is self-propelled. Dear Lord, that is so vague. That was intentionally created that way to deceive the masses. Indiana Code Section 9-13-2-105, which is what we just read, is the definition the courts of the state of Indiana use commonly when dealing with traffic offenses. This is because this definition refrains from defining its true intended purpose. The term motor vehicle falls under the subject matter of transportation by the will and intent of the legislature. This definition only applies under the governing subject matter, which is commercial use via transportation. If a private citizen is not engaged in transportation, the term motor vehicle is 100% inapplicable. The subject matter governs the objects that are placed under that subject in law. If the subject matter does not apply to the activity being engaged in, then neither does the definitions associated with the subject matter. Let's go further. Title 49, Transportation Code of Federal Regulations, Section 398.1. Motor vehicle means any vehicle, machine, tractor, trailer, or semi-trailer propelled or drawn by mechanical power and used upon the highways in the transportation of passengers or property, or any combination thereof, determined by the administration, but does not include a passenger automobile or station wagon, any vehicle, locomotive, or car operated exclusively on a rail or rails, or a trolley bus operated by electrical power derived from a fixed overhead wire, furnishing local passenger transportation and street railway service. It also further defines driver or operator. Driver or operator means any person who drives any motor vehicle. Interesting right there. We already know that definition. Let's go further. Title 49, Transportation, United States Code, Section 30102. Motor vehicle means a vehicle driven or drawn by mechanical power and manufactured primarily for use on public streets, roads, and highways. So as you can see, a lot of the definitions of motor vehicle that they have available to the public are deceitful. But they have to reveal the true intended purpose of it, obviously, and we will go over those as we already have. Indiana Code Title 8, Utilities and Transportation, Section 8-2.1-17-11. Motor vehicle means a truck, a tractor, a trailer, a semi-trailer, or a motor bus, or another self-propelled or motor-driven vehicle that is operated upon the public highway for the purpose of transporting persons or property for hire. Bam! We got it in the Indiana Code. There it is. The true intended meaning of that term. Let's go further. Indiana Code Title 6, Taxation, Section 6-6-4.1-1. Motor vehicle means a vehicle except a vehicle operated on rails which is propelled by an internal combustion engine or motor and is designed to permit its mobile use on public highways. Again, another vague definition. But if we look further, we can find the true intended meaning of it in the Indiana Administrative Code. 45, Indiana Administrative Code, Article 13, Motor Carrier Fuel Tax, Section 13-1-3, Motor Vehicle defined. A. Motor vehicle means a vehicle that is propelled by an internal combustion engine or motor and is designed for highway use. B. Vehicles designed for highway use are vehicles primarily adapted for and engaged in highway transportation. All vehicles plated for general highway transportation or capable of being plated pursuant to Indiana law are presumed to be primarily adapted for and engaged in highway transportation. We go to C. The term motor vehicle does not include vehicles not required to be registered under Indiana Code 9-18, including, number 2, vehicles not capable of being plated pursuant to Indiana law. And what are those type of vehicles? Private conveyances / private automobiles. Those vehicles that are not used in commerce. Let's go to D. The term motor vehicle includes vehicles with a common fuel reservoir for both locomotion along the highway and the operation of equipment with another commercial purpose. For purposes of Indiana Code Section 6-6-4.1, commercial purpose, 1, means the exchange of goods and services in contemplation of profit, and 2, includes non-proprietary functions of governmental agencies and not-for-profit organizations. There it is. The Indiana Administrative Code also has motor vehicle and commercial purpose in there defined. Now another term of art we're going to discuss is license. Now what is the definition of a license? According to Indiana Code Title 9 Motor Vehicles Section 9-13-2-93, License, for purposes of Indiana Code 9-30-10, has the meaning set forth in Indiana Code 9-30-10-2. So let's go to that. Section 2. As used in this chapter, license includes any type of license or permit issued by the Bureau to operate the type of vehicle being driven. Pretty vague, as usual. It seems only proper to define the word license, as the definition of this word will be extremely important in understanding the statutes as they are properly applied. According to People v. Henderson, the Supreme Court of the Michigan Republic in 1974, the definition of license is the permission by competent authority to do an act which without such permission would be illegal. I want you to take time to understand that, comprehend that. Let's go further. Next is State X-Rail Interstate Airports versus Minneapolis State Paul Metro Airports Commission. This is the Supreme Court of Minnesota Republic in 1947 defining license. The purpose of a license is to make lawful what would be unlawful without it. Let's go to Black's Law Dictionary. Black's Law Dictionary, revised 4th edition, pages 1067 to 1069, and we will read what's underlined here. The definition of license: authority or liberty given to do or forbear any act. Leave to do a thing which licensor could prevent. Permission by some competent authority to do some act which, without such permission, would be illegal. Permission to do a particular thing, to exercise a certain privilege, or to carry on a particular business, or to pursue a certain occupation. Permission to do something which, without the license, would not be allowable. To license means to confer right or power which does not exist without it. So let's look at it this way. Here's another interpretation of the term license. You get a permit, which permit is the same is synonymous with license. You get a permit for your shotgun. Okay? Remind you, you have the Second Amendment right to bear arms. So obviously you have the right to have a gun to protect you and your family, to protect your property, to whatever you need it for, in defense of your livelihood. Why in hell would you need a permit or a license to have a gun when you have the Second Amendment right to own one? See, it makes no sense. It's the same concept with traveling. Why do you need a license to travel upon the streets and highways in your own private conveyance / private automobile, which is your own private property? You don't need a license or a permit to do that. It is your God-given unalienable right. Let's go further. According to Black's Law Dictionary, 6th edition, page 495, driver's license means the certificate or license issued by a state which authorizes a person to operate a motor vehicle. Generally, a written and driving examination is required for obtaining such. Indiana Code Title 9, Motor Vehicle, Section 9-28-2-4. Driver's license means any type of license or privilege to operate a motor vehicle issued under the laws of a jurisdiction. Further, Indiana Code Title 9, Motor Vehicle, Section 9-13-2-48. Driver's license means any type of license issued by the state authorizing an individual to operate the type of vehicle for which the license was issued and the manner for which the license was issued on a highway. The term includes any endorsements added to the license. Let's look at the term endorsements. Indiana Code Title 9, Motor Vehicle, Section 9-13-2-49.6. Endorsements refers to any endorsement issued by the Bureau under Indiana Code Section 9-24-8-4 or Indiana Code Section 9-24-8.5. So let's go to that. Indiana Code Section 9-24-8.5-1. This chapter applies to an operator's license or a commercial driver's license that is issued or renewed after December 31st, 2016. Okay, pretty vague, didn't tell us much. So let's go further. 140, Indiana Administrative Code, Section 7-1.1-1. Endorsement has the meaning set forth in 49 CFR, which is Code of Federal Regulations 383.5. Okay, so now we have to go to the Code of Federal Regulations to obtain the definition. As used in this part, endorsement means an authorization to an individual's CLP or CDL required to permit the individual to operate certain types of commercial motor vehicles. So endorsements is directly linked to commercial motor vehicles. Indiana Code Title 9, Motor Vehicles, Section 9-13-2-48.3, Driving Privileges. Driving privileges means the authority granted to an individual that allows the individual to operate a vehicle of the type and in the manner for which the authority was granted. Indiana Code Title 9, Motor Vehicles, Section 9-13-2-41. Current driving license means every class and kind of license or permit that evidences the privilege to operate a motor vehicle upon the highways of Indiana. The term includes a privilege granted by the license. Title 49, Transportation, Code of Federal Regulations, Section 383.5. Driver applicant means an individual who applies to a state or other jurisdiction to obtain, transfer, upgrade, or renew a CDL or to obtain or renew a CLP. And ladies and gentlemen, a CDL obviously is a commercial driver's license, and a CLP is a commercial learner's permit. Title 23, Highways, Code of Federal Regulations, Section 1327.3. Driver history record means a detailed description of an individual's driver record used in the American Association of Motor Vehicle Administrators Commercial Driver's License Information System. So, during the process of when a private citizen visits the DMV/BMV to apply for a driver's license, that constitutional private citizen of the Indiana Republic or American citizen or state national is a driver applicant, which indicates he or she is applying to obtain or renew a CDL, a commercial driver's license, or a CLP, a commercial learner's permit. The definition of driver's license and driving privileges in the Indiana Code confers that the state authority, in this case the BMV, authorizes a private citizen to operate a type of vehicle for which the license was issued and the manner in which the vehicle is used. Contradictory to the implication type of vehicle or the vehicle of the type, the definition of current driving license specifically verifies every class and kind of license or permit obtained by the private citizen is a privilege to operate not just a type of vehicle, but explicitly a motor vehicle. And we know what motor vehicle is. The manner for which the license was issued or for which the authority was granted declares the intended use of the vehicle. If anyone is receiving or obtaining a driver's license, the vehicle one intends to use will be a motor vehicle because that is all the DMV/BMV deals with, the conveyances used for commercial purposes, which are motor vehicles. The requirement for a driver's license is the result of operating in commerce. Only when a private citizen desires to obtain a job or a career or operate a business of their own that involves using the highways as a means for profit or personal gain, such as a truck driver, a chaperone, an in-home care physician, etc., then one must get a license and register their conveyances. Once accomplished, then their private conveyance/private automobile is pledged as public property because their job is a service to the public who automatically has an interest in it. Let's go further. Indiana Code Title 9, Motor Vehicles, Section 9-24-1-1. Except as provided in Section 7 of this chapter, an individual must have a valid 1. Driver's license or 2. Permit, including any necessary endorsements issued to the individual by the Bureau to operate upon the highway the type of motor vehicle for which the driver's license, endorsement, or permit was issued. Indiana Code Title 9, Motor Vehicles, Section 9-24-13-3. An individual holding a permit or driver's license issued under this article must have the permit or driver's license in the individual's immediate possession when driving or operating a motor vehicle. As you can see, all of these driver's license, driving privileges, driver record, it all deals with drivers, it all deals with motor vehicles, it all deals with commerce. Further stated in Section 9-24-13-3, the individual shall display the driver's license or permit upon demand of a court or a police officer authorized by law to enforce motor vehicle rules. So, of course, you got to have your driver's license in hand. You got to have all of that available, your license plate, insurance, all that, because you are operating under the motor vehicle rules. And, of course, police officers and judges will uphold those motor vehicle rules. Let's go further. Let's talk about the burden of proof. Indiana Code Title 9, Motor Vehicle, Section 9-24-13-6. Subject to subsection B, in a proceeding to enforce Section 3, which is possession and display of licenses and permits of this chapter, the burden is on the defendant to prove by a preponderance of the evidence that the defendant had been issued a driver's license or permit that was valid at the time of the alleged violation. Of course, you got to prove your innocence. You're automatically considered guilty
until proven innocent. And that is not how due process works at all. That is the complete opposite way of how the American society handles the judicial system. Indiana Code Title 9, Motor Vehicles, Section 9-24-18-6. In a proceeding to enforce Indiana Code 9-24-1, which is individuals required to obtain a license or permit, requiring the operator of a motor vehicle to have a certain type of driver's license, the burden is on the defendant to prove by a preponderance of evidence that the defendant had been issued the applicable driver's license or permit, and that the driver's license was valid at the time of the alleged offense. Pursuant to Indiana Code, Section 9-24-18-6, this statute informs the private citizens that when the local government officials attempts to enforce motor vehicle rules in traffic court, the operator of the motor vehicle has the burden to prove by a preponderance, which is a majority of the evidence, that he or she has been issued the applicable driver's license or permit. This indicates that the governing authority that's in charge of determining what driver's license is applicable or appropriate for the private citizen to have, in this case the BMV, must have obtained information from that constitutional private citizen to help them identify what class of driver's license was needed for the vehicle he or she would be using upon the public streets and highways. This information is gathered during the application process as a statutory requirement pursuant to Indiana Code Section 9-18.1-3-1, which will be discussed further in detail shortly. Pursuant to AAA Digest of Motor Laws in Indiana, and here I have the website highlighted, and I will have it posted up on the screen. The state of Indiana issues various types of driver's license for different purposes. There are 6 classes of driver's license, which include 1. Operator's license, 2. Chauffeur's license, 3. Public passenger chauffeur's license, 4. Motorcycle endorsement on a license, 5. Learner's permit, and 6. Commercial license. Pursuant to the Indiana.gov website, which I also have highlighted right here, and I have it posted on the screen, the BMV will no longer issue chauffeur or public passenger chauffeur licenses. The for-hire endorsement to an operator's license is now required to operate the vehicles listed below. These vehicles are not subject to CDL requirements." End quote. Out of all the 6 different classes of driver's license, an operator's license is issued to the majority of those who apply for a driver's license. That applies here in the Indiana Republic. Guaranteed, all you watching this who are located in the Indiana Republic, as well as any other state of the union for that matter if you are issued an operator's license, guaranteed, when you went to apply for a driver's license, that's what they issued you, an operator's license. Unfortunately, ladies and gentlemen, our time has been cut short. We will continue this in the next episode of Learning the Law. We will talk about an operator's license and what it is. We will also be continuing to go over case law and plenty of more definitions, plenty of more statutes from the Code of Federal Regulations and the United States Code. We have so much more to cover. You are definitely going to want to tune in next time on Learning the Law.